Good afternoon, Ms. Van Zyl.
Good afternoon, Chief Justice. Thank you for the opportunity of being here.
It's our pleasure. How are you?
I'm nervous, but I am otherwise well. Thank you, Chief Justice.
It's good to be nervous. You are a product of GovSys. You obtained your BUris cum laude and an LLB there, and then
Yes.
did your LLM in corporate law with UNISA.
Yes, I did the LLM while I was working already. I was working at that stage at the Joburg municipality.
You tutored at UCT for a brief spell,
Yes,
then worked for the provincial government for another brief spell as a legal admin officer,
yes.
and then worked for Joburg municipality as a legal advisor for another shortish spell.
Yes, just after I finished my LLB, Chief Justice, I wanted to spread my wings a little. I came to Cape Town and accepted the position as a tutor at the law faculty at UCT, which was very interesting. And already at that stage, I saw how important it was to inspire students, young people. But thereafter, it was a brief spell. I received an offer to go to the Western Cape provincial government as a legal administration officer. That was for also a fairly short period, just over a year. And from there, I went to Joburg municipality, and there I was for about 2 years before I joined the bar.
All right. But then you decided to join the bar in 2001.
Yes. While I was at the municipality, we very often had interesting local government matters to deal with, amongst others, and we would invariably give those matters over to counsel and attorneys, and I was feeling like I was missing out and inquired about pupillage and decided to go to the bar.
And you never look back.
No, I've enjoyed practice.
What kind of practice have you been running?
It is a fairly general practice, but you would have seen from my application form, I did some criminal law at the beginning of my career, a trial and some appeals. Thereafter, it seemed to morph into a fairly administrative law-laden practice, obviously with aspects of constitutional law that attach to that. I have also done a fair amount of general civil work, contract, commercial work, delict. I've done some arbitrations, tribunals, various tribunals, heritage work, planning, disciplinary hearings. Labor law, again, is a field of the law in which I've only practiced a limited number of times there. So that is also not a big part of my practice. So I would say probably commercial, general civil, and administrative law are the broadest facets of my practice.
All right. And you are an arbitrator as well?
Yes. I've sat as arbitrator in more than one case. I've also obviously taken part as a party, as a representative in arbitrations.
And you have written, was it articles which have been published in LOSA?
I've not written articles published in LOSA, but I have updated 3 of the titles in LOSA.
All right.
Yes.
And you updated interdicts as well?
Yes. That has not yet been published.
I see that. All right. So you want to become a judge now?
I do, Chief Justice.
You've acted in this division in which you seek employment.
Yes, I've acted for basically 60 weeks. That comes to 6.5 terms.
Yeah.
That was 3 terms during 2022, 3 during 2023, and then for a month this year, July, August. I'm currently acting as well since the 7th of October. I'm acting until the end of the year.
Okay. And you've had opportunity to write the judgments whilst there.
Yes. I have written 112 judgments by now. There is a list of judgments attached to my application form, just setting out or giving an indication that they cover a fairly wild field. They have been mostly civil, of a civil nature. I have also, however, done a criminal trial, about 9 bail appeals, of 9 criminal appeals, of which I was the scribe in 6 of those appeals. I've done 7 bail appeals, a bail application, countless reviews, automatic reviews from the magistrate's court. I've had a fair spread of work, and very interesting work, for which I've been very grateful.
Yeah. Have you done any criminal work in the High Court?
I have, as I've mentioned earlier, I've done criminal work at the beginning of my career. So it is a long time ago. I acted or represented an accused in what was at that stage something that was very topical, a cash in transit heist. That was a long-running criminal trial. And when I started in legal practice as well, the Legal Aid Board didn't have in-house legal counsel to deal with their criminal appeals. So I did countless criminal appeals on Friday mornings.
All right. And I take it you would have done, you've sat in the criminal court in the High Court.
I have, Chief Justice, you mean that as a judge?
Yeah.
I've completed 1 criminal trial. I think I mentioned in my application form at that stage, sentence was still to be handed down. I've done so on the 25th of June. That was a 2 accused murder trial in which the minimum sentence legislation was involved. And then, apart from that trial, as I've stated, I've dealt with 9 criminal appeals of a wide-ranging nature, 7 bail appeals, bail application, reviews, criminal reviews from the magistrates' courts.
All right. And you reckon that is enough experience?
One can never have
Well,
enough.
I
Yeah.
ask because one of the professional bodies has expressed
Yes.
concern about the fact that you seem to have little criminal law experience.
Yes, thank you, Chief Justice. That is, I've read that comment and I've thought about it. It is a very valid remark, but one never stops learning in this job. That was one of the things that impressed me when I first started acting, and I have always tried to tackle whatever I'm allocated head on. I enjoy criminal work. I would like to do more of it, and I believe that with the litigation and general experience that I have, I will be able to deal with criminal matters as and when they come my way.
Okay. There is something else this professional body expresses concern about. They say you have no human rights background and no interest in helping previously disadvantaged communities.
Yes, I've read
Is that a fair comment?
I've read that too, and I've thought about it, and I have perhaps not expressed myself clearly enough in my application form. I'm sorry if that is the case. My community, and I think that the comment comes from the fact that I had indicated that I believe in being helpful in my community. Well, my community is South Africa as diverse as it is, and I mean where I practice, where I live. And I have had many opportunities, whether professionally or in my personal capacity as a private citizen, to assist and mentor and uplift. It is true that I am not a member of any organization that goes out to do upliftment work, but I have in the course of my career tried to be available where I can to mentor especially young women, and I'm glad to see that there are so many young women at the bar these days, but I could perhaps even started my involvement in tutoring at UCT. At that stage already, I could see that there is a need to assist persons who might not have had the educational background that I had, to uplift them, teach them, mentor them, so that they can become fully fledged members of this profession. And I'm glad to say that quite a lot of the people that I met there are respected legal professionals at this point. I've also at the bar mentored 5 pupils. I have been a member of the bar advocacy training program for a long time, sat in countless moot courts on Saturday mornings. I also have an open door approach, and it appears to me that young people, younger practitioners feel comfortable in approaching me with questions. It happens time and again, and I do it gladly, questions about how to approach a matter, looking at pleadings, assisting with the way forward in a matter, sometimes saying, look, you have to settle this. So it's even, I might even point to something that happened the other day while I was acting. A young attorney came to my chambers because I needed to give her directives in relation to an unopposed matter. And after I had assisted her, she told me that she found me to be very kind and helpful, and if she asked whether she could ask me again for advice, to which I said yes. And she said that she would like to be like me. She aspires to be like me in my position one day. So that was extremely humbling. And it shows that if one is kind and open and helpful with everyone who comes across your path, in that small way, one assists in transformation of the mind as well, apart from transformation on a practical racial level. I've also, in my private capacity, I've had the privilege of paying the educational expenses of a young woman who is writing matric this year, and we are looking at college options for next year. And I'm very pleased to say that a door has opened for her. She has options, and she can go out into the world with opportunities that she would not have had I not been able and fortunate enough to assist her.
Thank you, Ms. Van Zyl. AJP?
Thank you, Chief Justice. Advocate Van Zyl, considering the fact that you have written, did you say 112 judgments?
Yes, AJP.
Yeah, I can attest to the fact that you have an excellent work ethic, a very good work ethic. How did you find your acting periods at the Western Cape High Court in relation to the support provided by permanent judges?
Excuse me, AJP, by permanent judges?
Yes, you were there 2022,
yes,
2023, yes. And 2024. What was your experience, and in terms of your relationship with permanent judges and the support provided by permanent judges?
AJP, I was pleasantly surprised at the very, very collegial way in which I was treated. I mean, I'd never acted before 2022. I didn't expect to be treated as an equal, but I felt that I could take part in discussions, I could ask questions. The permanent judges were exceedingly helpful if I felt that I needed assistance on any aspect. And that really made me feel welcome at court. When I go into that building, I feel as if I'm at home. I feel at home there.
Is my impression correct that your strength lies in commercial work?
I would say commercial work as well as administrative work. Civil work, certainly, maybe to put it a little more broadly.
Do you have anything you'd like to say about the workload at the Western Cape High Court? Because the tap never closes.
No, it doesn't, AJP, but that is one of the things that makes the work so interesting. There is work of a wide variety. I enjoy tackling each and every new file that comes across my desk. I am happy to serve the people of the Western Cape. I'm happy to serve the bench in getting that workload down as far as one can. I'm certainly trying to do my best in making a contribution to assist.
Is it 9 reported judgments that you have?
Yes,
Is that
AJP.
the number?
Yes, AJP.
And with regard to any of your matters, were they ever taken on appeal?
Yes, AJP, I've mentioned it in my application form. There was three of them that I'm aware of. The first one, it's on page 21. Let me just make sure. Yes. The first one was a matter in which I granted declaratory and ancillary relief to allow applicants to work as acting sheriffs for a specific period. That matter was taken, I granted leave to appeal in that matter. It was taken on appeal, but ultimately the full bench felt that the issue had become moot by the time that they dealt with it, and they therefore dismissed the appeal for mootness. The second judgment, in which I also granted leave to appeal, was a summary judgment application, in which I had granted summary judgment basically on 3 bases. The full bench held that on 2 of those bases, I should have granted leave to defend because it felt that a tribal issue had been raised on those. And then the third was a judgment that I sat in as a tax, I sat as a tax court under the Tax Administration Act. It was a matter dealing with the interpretation of Rule 32 of the tax court rules. The full bench upheld my judgment. In other words, dismissed the appeal. I do understand that that matter is before the Supreme Court of Appeal at the moment, but it is pending. I do not know what the status thereof is.
Thank you, Chief Justice.
Mr. Posho?
Thank you, CJ. Afternoon. Ms. van Zyl.
Afternoon, Mr. Bosse.
So, at risk of preaching to the choir, you would know that the Western Cape Division has quite a heavy administrative law caseload. So I'm just going to ask you 2 broad questions dealing with admin law principles.
Yes, Commissioner.
So the first one deals with interim or so-called Part A and Part B applications Part B is the application for a judicial review of an administrative decision. And then pending that, the applicant then also launches a Part A when it seeks to interdict the furtherance of that administrative decision. So for practical terms, to make it easier, I suppose, let's say it's a tender, an award, so to halt the implementation of the contract, they bring an interdict. There's been a few cases on it, but there's a growing tendency of litigants or applicants to then try and rely on their very right to review, the Part B. They rely on that right to review and the Section 33 right to fair administrative action to establish a prima facie right in order to meet the requirements for an interim interdict. What is your view or your assessment of that and your view on how courts have dealt with that?
Well, there are two aspects, if I understand the question correctly. The first is that one cannot in any event rely directly on Section 33 of the Constitution because of the principle of subsidiarity. In other words, because PAJA has given content to the right to fair administrative action, one goes to PAJA for that relief. But apart from that, in any event, the right to review, that is a right that one has that doesn't need to be protected by an interdict. And that accordingly doesn't give rise to a prima facie right under the principles or the requirements for an interim interdict. One will have to show that that there is some substantive right that will be irreparably harmed should it not be interdict. But that is most certainly not the right to have your review heard in due course.
Okay, thank you. And then the second question is, and I think by way of example, a landowner is approached by the municipality. They show an interest in the land for human settlements development purposes. They negotiate terms, and then it results in the conclusion of a sale agreement. It then subsequently comes to the fore that the municipal council had failed to comply with prescripts empowering provisions in the Municipal Finance Management Act. There was no, let's say there was no council resolution, which was a key empowering requirement to conclude that transaction. As a result of that, the municipality wants to wash its hands of the contract. The landowner goes to court and says, I want to rely on estoppel. I want to ask the court to use my reliance as an innocent third party or an innocent contracting party to enforce this contract and force this contract upon the municipality. In other words, the question is, would a court be within its rights to enforce a contract in circumstances where underlying it is action ultra vires the powers of the municipality, if that makes sense?
It makes sense. Thank you, Commissioner. Well, the first aspect is that one cannot use estoppel to confirm an illegality. And then one goes to the doctrine or the principle of legality. All states, including, in this case, municipality, the actions of the municipality must be in accordance with the principle of legality, must be lawful, and within what the municipal powers are, for example, within the context of the MFMA. So, unfortunately, for the third party, he or she would not be able to rely on estoppel in order to enforce that contract. I suppose that, because as I've said, if the municipality's actions are unlawful, that is the end of it.
Just a nuance on that now. Let's say, for instance, it wasn't a case of clear lack of power. They had ostensibly the power, but they hadn't complied with some internal process or something. Would that potentially change the situation?
May I ask, Commissioner, if inherent in that question, the fact that they haven't complied with some internal procedures still rendered the conclusion of the sale unlawful? Because it sounds to me like a reliance on the Toerkwant rule, and in that case, that would also not assist the third party.
No, I think we don't need to go any further than that. That's where I was heading with it.
Oh.
Okay. No, thank you very much. Thank you, CJ.
Commissioner Rickes?
CJ, good afternoon, Advocate.
Good afternoon,
Yeah,
Commissioner.
I was not going to ask you a question, but there is this case of SOHCO, Property Investment NPC versus Temet. You know
Yes.
that case?
I remember that case.
This is a case concerning eviction.
Yes, yes.
Now, on the main case, this regarding costs, this is what to say, paragraph 163. There was no reason for costs, including the cost of two counsel, not to follow the event, even though it is unlikely that SOHCO will be able to recover any costs. This is a
Yes.
case based on par. You say, I mean, they don't have money. That's what they say. They cannot afford this cost.
Yes.
But
yes,
nonetheless, I order costs, including costs of two counsel. I'm asking you this question based on the comment against you that you do not uphold the constitutional values. Don't you say that this impact on access to justice?
Thank you for that question, Commissioner. In that case, it was a case in which there were various technical defenses to the application for eviction, and there were many nuances to it, and in my discretion, in the exercise of my discretion, although it appeared to me that the persons who stood to be evicted would probably not be able to pay a cost order, it didn't seem to me to be a case in which I should, only for that reason, deviate from the general rule as to costs.
I mean, the whole issue of land, I mean, that is land occupation and the right to housing, human settlement. This is a contentious issue in the country. And in this case, clearly, these were people, ordinary people, that have been some in those flats. Some have ended because they have no shelter. That's why in your leave to appeal subsequent, you say the municipality must provide to them
Yes.
emergency temporal.
Yes. Yes.
Really, did you not have a discretion to exercise regarding costs? Is it not that the cost, in question consideration, of course, has a discretion?
Commissioner, I hear you, and I accept the point. In my consideration of that matter as a whole, of the way in which the litigation had been dealt with and the various aspects that had to be decided, I felt that in the exercise of my discretion, I followed the general rule in relation to cost. But if I have to deal with the same sort of matter again, and there may be other principles involved, other facts, I might well reconsider that.
Yeah. Lastly, in the leave to appeal judgment, again, you make a funny remark because you say, in light of the lapse of time, sorry, just before that, regarding one discerned cost, as in the main application, there's no reason for cost not to follow the results, even thought it is unlikely, therefore we'll be able to recover costs and then go on. But very important, this is what.
Yes.
What is before you is the leave to appeal.
Yes.
You decide to dismiss the leave to appeal, but you grant other substantive reliefs where you say the municipality must provide temporal accommodation and you provide a timetable by when these people must be evicted. That was not even before you.
Commissioner, that relief was in fact part of the main judgment, but because of the time that it had taken for the leave to appeal process to be finalized, I extended the time period within which that had to be done in the application, or in my judgment on the application for leave to appeal.
And the essence of my question. The question is that the relief you grant, what was before you was the leave to appeal. That was what was set down.
Yes.
Now, when you give your judgment, you go beyond, you grant some orders where you say the city council must, before a particular date, must give them temporal shelter, they must be removed. You haven't even asked if the municipality would be able to do those. That's what I'm bringing to you, that you grant, you just end on a frolic of your own, because there is no application, you have no basis to do this, even if the application was said late or there was a delay, but you didn't have evidence.
Commissioner, I had the evidence that I obtained in the course of the argument of the main application. If I remember correctly, the reason for the additional, it was an extension of the relief in a sense, if I could remember correctly, in the judgment on leave to appeal arose from the commando judgment in the Supreme Court of Appeal, which indicated that because there was a time lag between the original judgment and when and what would have had to happen to the evictees at that stage, and the judgment given in relation to leave to appeal, there were certain aspects that needed to be tweaked, and additional time had to be given for the municipality to assist. So that was the reason.
Chief Justice, I have no further questions. Thank you.
Commissioner Mangan?
Thank you, Chief Justice. Good afternoon. It's still afternoon. Good afternoon, Advocate. Yeah, just to follow up on this question of the costs,
Yes.
There is also something that bothered me. In the case of Waynard versus the municipality of the City of Cape Town and two others, this was an application for an interdictory relief pending the rezoning. And the municipality, as the first respondent, had actually appointed a senior counsel and or two counsel. And on the costs, you allowed cost of two counsel on a matter that I think it was very simple, which did not require two counsel. And following up on the question that was posed by Commissioner Nojes,
Yes.
it creates an impression that when it comes to costs, you favored the city or the city council.
Commissioner, I most certainly didn't favor the City Council. The City Council was entitled to the cost. This was, Wynand was an application for an interdict with wide-ranging aspects to it, constitutional aspects to it. I certainly thought that the dealing with it justified the use of two counsel, and for that reason, I gave the costs of two counsel. But you would have seen that the municipality asked, or the city asked, for costs on a punitive scale, which I did not grant.
No,
But
so-
it was certainly not in an attempt to favor the municipality. The municipality won this hands down.
And certainly, and that is actually the cause for concern, because the applicants had actually sought to assert their constitutional rights, their right to privacy, their right to property, relying largely on Section 25. And one would have thought that, given the fact that this was an interim relief, you would afford them an opportunity to have their matter argued, even if you were to grant costs, and considering that it's an interim one. Those costs, one, either you would have said that the cost would be cost in the main action, or you would have reasoned adequately why you discount the fact that they were advancing constitutional rights, because we know that costs have a chilling effect on litigants. And
Yes.
because the impression created by this judgment and the lack of reasoning on the cost aspect says that they were really being intimidated never to even think of bringing or continue with their Part B of the application for final relief.
Thank you, Commissioner. I'll answer that. I think that the judgment speaks to a large extent for itself what the applicants did. They were seeking an interim interdict, but what was clear from the outset was that, in effect, they were intending to seek a final interdict, stopping the municipality, prohibiting the municipality from ever deciding on a rezoning application. That is not, that takes us back to constraints on the exercise of a municipality's executive power, but be that as it may, the applicants also relied directly on, for example, Section 33 of the Constitution and on Section 195 of the Constitution. They simply had a case which had no merit whatsoever. Now, they did not argue the BioWatch principle in front of me, but I remember thinking about it. BioWatch has a proviso to it, so to speak, to say that even if there are constitutional aspects involved where cases are patently without merit, and I wouldn't have gone so far as calling this case frivolous, but it was without merit, then there's no reason to depart from the general rule that the party bringing, or the unsuccessful party, should pay the costs.
Thank you, Chief Justice. Thank you, Advocate.
Thank you, Commissioner.
President Molenaar.
Thank you, CJ. Good afternoon, Ms. Van Sey.
Good afternoon, Commissioner.
You stated in your questionnaire that criminal law constitutes 5% of your practice. And I think you also stated that you, as an acting judge, you conducted two criminal trials. Is that correct?
Commissioner, no,
Let me rephrase. How many criminal trials did you conduct as an acting judge?
I conducted one criminal trial.
One. What was the duration?
It started mid-2023 and concluded mid-2024. I gave judgment on the merits in February 2024 and judgment on sentence in June.
How many accused persons were involved?
There were 2 accused persons involved. It was a matter where robbery with aggravating circumstances, murder, and defeating the ends of justice.
Have you attached that judgment?
I have not attached it to this. No, I haven't.
If I may ask, why not?
It wasn't a reported one. I understood that reported judgments had to be attached, or 10 of them. Also, it was a judgment that, although it dealt with a fair spread of criminal law issues, I didn't think that there was anything particularly new about it, if I could say it in that sense. I learned a lot from it, but it was a properly reasoned criminal judgment. The accused were found guilty on the basis of circumstantial evidence. There were applications for Section 174 discharge after the close of the state's case. I dealt with that. Minimum sentence legislation was applicable that I had to consider in the course of sentencing.
Thank you. And under what circumstances would you order the holding of a trial within a trial?
If there is a dispute, for example, about the admissibility of certain evidence, such as a confession or certain admissions, other evidence, any aspect without a determination upon which it would hamper the continuation of the trial if one doesn't have a ruling on that aspect before carrying on.
How is it conducted?
Excuse me, I do not
How
understand.
is a trial within a trial conducted? So the trial has begun, and you consider it appropriate to hold a trial within a trial. What happens in the trial within a trial?
As far, I confess that I haven't done one, but it is conducted as far as I am aware, and I would have to research this, as a mini trial within the bigger trial. In other words, one hears evidence about the limited issue at hand from both parties. They can call witnesses if necessary, and then one makes a ruling based upon what comes out of that.
Thank you, Ms. Van Zyl. Thank you, CJ.
There are no more questions for you, Ms. Van Zyl. Oh, I didn't see that hand.
Sorry, CJ. Thank you. Advocate Vinsel over here. Thank you.
Thank you, Commissioner.
Yeah, always easier to do it that way. Advocate, I just want to ask you a little bit further on the transformation matters. And I think it is important because so often we think that we can't make a difference in our everyday lives, right,
Yes.
to the systemic change. And we must be very clear, in order for us to reach the goals of what we want to create South Africa to be, both in a general sense but also in a legal sense, transformation has to be an active process.
Yes.
Yeah, and I'm glad you agree with that. Because most of the candidates before us today, if you read their paperwork and you've asked them, they've dedicated their entire lives and careers to the transformation of the legal fraternity. And I'm a little bit concerned that, have you done enough to advocate for transformation in the space? I understand that there have been the mentorship of black pupils. You've mentioned a few, but those are assigned. That's important to note. And I think the greater issue here, CJ, is that helping one or two people is not going to systemically change anything. And when you are interviewing for a judicial post, particularly a judge in the Western Cape, I think we do need to see a track record of transformation. Do you have any response?
Yes, I agree with you. I don't think that one can ever do enough. One asks, what is enough? And one can always do more. But as I have mentioned, I have consistently, and not just once or twice, but consistently assisted women of color, through my profession, with what I can give. As I've indicated, I'm very approachable, and that makes people and young colleagues confident enough to ask me at any stage and for any advice. And I think in that way, I have certainly contributed. It is a daily process. It's eating at the bigger pie in small bites. And it is also important. It's important how one treats people, because as I've mentioned, there is transformation stems also from how one deals with people. For example, also how one deals with unrepresented persons, which happens often in court, explaining to them their rights so that they don't feel that they leave the court without having obtained justice or a sense of justice. And then, again, as I've mentioned, at least for one young woman, I have opened doors, and I'm grateful to have done that.
Just as follow-up, CJ, how many Black African women have you brought with you into the space? And I say this because when you have a seat at the table, it's not enough. You need to create a streamline for others who are disadvantaged to enter. And I appreciate individual effort, but I'm trying to show you that we need to do a little bit more. But let me understand, how many Black women have you brought with you?
I'm not sure that I understand Black women.
How many
brought with
Black
me.
African women have you actively, through your practice and through your judicial work, empowered actively? Not passively, actively.
Well, obviously my pupils, I have two of them. Then bringing people into the space actively, and I hear what you're saying, but giving advice, helping them with their cases, helping them with their pleadings, it's difficult to say offhand how many, but I have certainly supported and encouraged, even when people were feeling that they needed to leave the bar, throughout my career. I have tried to.
Okay, thanks. Just in closing, CJ, perhaps there is worth, Advocate Van Zyl, to joining some of these organizations and bodies in the legal fraternity, so that you can couple whatever minimal efforts you might be doing to actively empower the Black majority who are disenfranchised in our country. Thank you.
Yes, thank you, Commissioner. I think that my efforts are sustained, and they are, I wouldn't call them necessarily minimal. They may not be organized, but they have made a difference to many people.
No, Chief Justice, let me leave it, because I was also going to talk about transformation, but I think that maybe let me ask, because I was trying to find a way of rescuing the problem, if there is. See, because the AFT from the Western Cape says that you look like you're a good advocate, but we must ask you about transformation, because they themselves, the Black advocates who practice there, are not aware of any role you've played in transformation. Now imagine if the Black advocates in your division don't know what you've done for transformation. We are 3 times removed. So there are many things you can do for transformation.
Yes.
I no longer accept the excuse that, no, I couldn't do anything. So you could join the organizations, you could be in committees, you could be in training, you could be in pupillage, or you could do what Commissioner Hassan is asking, which is when you are in a brief, you motivate for the inclusion of a Black person. I've looked at your own cases. It's an impressive list, and you've been with top 6 from Cape Town. but I don't see anywhere where there are any black people that you've included yourself with. You could also do things outside of the profession. So there are so many things. But I think the anxiety is you're not coming clear about the tangible things. You talk in nebulous terms about your commitment to transformation, and not in tangible terms. So if you could just give us examples, 3 examples, 4 examples, 5 examples, that
Thank you.
demonstrate your practical commitment to transformation and not in a very generic, high-flowing sense.
Thank you, Commissioner. As I've indicated, I've had black pupils. I have also
Could you just
served-
stop the issue of pupillage? Because it's a compulsory requirement of every advocate that they should have pupils. That's not your contribution to transformation. You are forced to have a pupil.
I enjoyed having pupils as well. I was for many years a member of the bar's advocacy pupillage training committee, and in that capacity, I assisted many black or pupils in general in advancing advocacy techniques. I have also shared fees or reduced my fees in 2 matters so that a black junior could be taken on. One was in a long-running application proceeding in which there was a parastatal involved. The other was in review proceedings against a municipality. And then, as I've mentioned, in my private capacity, I have put someone through school.
Thank you, Chief Justice.
Thank you, Commissioner.
Chief Justice, I think I'll let this pass because I don't think the candidate understands really what transformation is all about. And my problem is that she actually said she read people, she taught people about their rights. That's your job. You are a legal practitioner, you need to do that. But I think I'll leave it there. It's quite sad that you don't understand what transformation is all about. Thanks.
Thank you, Commissioner. I must say that I do not agree that I do not understand what transformation is. I've tried to, in the way that I conduct myself, in the way that I deal with people, promote transformation on all levels. And it's a work in progress, and I'm committed to that.
Commissioner Lekganyane?
No, Chief Justice, thank you so much. Good evening, Judge Van Zyl.
Good evening, Commissioner.
I'm sorry to say Steenkamp. Van Zyl. I just want to check if the 2 cases that you mentioned, 1 or 2 cases of transformation, do you still remember the names of those people that you assisted?
Yes. One was Cecil Saghari, who is now a very successful advocate at the Cape Bar. The other one was Adrian Monsiger, who has, in fact, acted in the division recently.
Chief Justice, thank you so much.
Thanks, CJ. Just a closing. So, as I understand it, in those cases where you undertook a fee-sharing arrangement, those were quite actually some weighty matters, which actually gave those fellow juniors exposure to work that, from my own experience at the bar and subsequently, is quite jealously guarded between seniors and juniors who do get that work.
Yes, it was full-on administrative planning law. The one, the other was about aspects of petrol or fuel setups, the safety circles around
Yeah.
it.
And,
So it was
yeah.
important matters.
And what was their contribution to these matters? Did they assist in drafting and consulting and what?
They took part in every part of the proceedings, assisting with consultations, drafting opinions.
Yes, and in fact, if I'm not mistaken, Acting Judge Monsinger actually recently wrote a judgment on the whole reliance on prima facie rights and the right to review in interim interdicts. So clearly, I mean,
You got
there's
something out of it.
Yeah, what I'm trying to say is it has potentially, at least in some way, assisted in the building of further administrative law practices at the Cape Bar, seemingly.
Most certainly, Commissioner.
Thank you, CJ.
The mic is off. You're excused, ma'am. Thank you so much for making yourself available.
Thank you. It was a privilege to be here. Thank you, Commissioners and Chief Justice.